Hello, can everybody hear me? Can everybody hear me? Good morning, everyone. Today we are going to be going over an overview of Title VI, Compliance and Enforcement. My name is Brandon Woosley, and I am a staff attorney here with the Tennessee Coalition. So what is Title VI? Well, Title VI is a federal law which prevents any entity from receiving federal money. It prevents them from discriminating against anyone based on race, color, or national origin. And what does the law itself say? Well, it says that no person in the United States shall, on the ground of race, color, or national origin, be excluded from participation in, be denied the benefit of, or be subjected to discrimination under any program or activity receiving federal financial assistance. Here, persons is described as, or defined as a citizen or a non-citizen, documented or undocumented individual, and it can be a corporation or an individual. The United States also includes all territories. For a lot of our programs, financial assistance does include grant-funded agencies. And when it says subjected to discrimination under any program or entity receiving federal financial assistance, this means that the law only applies to entities that receive federal funding. An aggrieved party may not sue an individual or an employee of a program under discrimination under Title VI. So what programs are usually covered? We have elementary, secondary, and higher education, healthcare, social services, public welfare, public transportation, parks and recreation, law enforcement, housing and community development. Social services could be the Department of Child Services. Some examples of what is not covered: employment and discrimination based on age or sex. An example of employment that's not covered would be if the recipient is building a temporary shelter with funds designated to provide assistance to the homeless. The employment practices of the recipient with regard to the construction of that facility would not be subjected to Title VI. However, if that same recipient builds that same facility with funds received through a program or a public works program whose primary objective is to generate the employment, that employment would be subjected to Title VI. In the former case, the program's benefit was to provide a shelter. In the latter, the program's benefit was employment of individuals. So, to sustain a Title VI claim for employment discrimination, the plaintiff is going to have to show that the recipient of the funds received federal financial assistance, and two, the primary objective of the federal funding is to provide employment. Discrimination based on age and sex is not included in Title VI, but there is Title VII implications that could be in play. Again, what is federal financial assistance? We have grants, training, use of equipment, construction money, donations, other federal assistance. Most of our nonprofits and victim service agencies are going to receive federal financial assistance through grant money. If your agency or your entity receives even $1 of federal money, then Title VI is going to apply. Also, an example of construction money assistance would be, let's say the federal government gives a grant to build a law school. There's a clear indication that you are receiving money to construct a law school. And after the law school is built, if that university still uses the school, it's going to have to comply with Title VI. Even though the money's no longer being received to build the building, just simply using the money to construct that building and then continuing to use that building, Title VI will still apply. The clearest way to see if you are bound by Title VI is to look at it as a contract. If you choose to accept federal funds, then you're agreeing to be bound by Title VI and there are other regulations that apply. Also, it's important to note that if you are an agency or a subrecipient, Title VI has implications for you. If you are the subrecipient, but the overarching agency that receives the direct funds from either the federal government or from the federal government through a state grant, Title VI is going to apply to both that direct entity and the subrecipients. And if you are the direct recipient of those federal funds and you have subrecipients, it's going to be your responsibility to ensure that the subrecipients are complying with Title VI. So what is the actual purpose of Title VI? Well, the purpose of Title VI is to make sure that everyone has access to federally funded activities. Such activities include WIC, court access, free legal service, and public transportation. Purpose of Title VI is to encourage the participation of minorities as members of planning communities, advisory bodies, or boards of directors for programs receiving federal funds. Purpose is also to prohibit discriminatory activity in a facility built in whole or in part with federal funds. And the purpose is to require information and services to be in languages other than English when provided to a significant number of beneficiaries who are limited English speaking abilities. What activities are prohibited? In operating a federally assisted program, your agency cannot, on the basis of race, color, or national origin, either directly or through contractual means, deny program, services, aids, or benefits, provide a different or inferior service, aid, or benefit, or provide a benefit in a manner that's different than others, and you cannot segregate or separately treat individuals in any matter related to the recipient of any service, aid, or benefit. Direct impact is going to be more obvious, but there is something called disparate impact, and this is usually seen when a policy or a program disproportionately impacts minorities or lower income populations. It can give rise to Title VI claims. And an example could be locating landfills consistently in a highly populated African American community. In determining whether Title VI has been violated, it is an intensely fact-specific inquiry. To determine if Title VI has been violated, you'll need to consider the proportion of persons in a protected class who are adversely affected by a policy compared to persons not in a protected class. If a highly proportionate number of individuals in a protected class are affected, you could have Title VI implications and violations, but you'll have to take the affected parties and weigh that harm against a benefit or against harm to others. An example could also be, let's say that a hospital is moving facilities and it is moving from a large African American community. By moving out of this community, it is obviously causing a harm to that community. It's going to be harder for them to have access to the healthcare services provided at that hospital since it's no longer there. But in moving, it might be moving to a more conveniently located place for the general public or even another community in general. Again, it is highly fact dependent, and there could or could not be a violation depending on the harm and benefits being weighed. Earlier, we mentioned limited English proficiency, and that is what LEP stands for. What it applies to is individuals who are not speaking English as their primary language, and they could have limited ability to read, speak, or write, or understand English. The federal government recognizes that this is the possibility, and it requires those receiving assistance from federal funds to take reasonable steps to ensure that LEP individuals have meaningful access to programs, services, and information that those programs and services provide. What are some of the LEP requirements? Again, this is going to really depend on what could be considered reasonable. The covered agency is required to take reasonable steps to ensure meaningful access. Reasonable steps could include utilizing interpreters, posting signs in Spanish or another language that would be the dominant language of a large portion of your clientele, or using language line or other phone services to serve as interpreters. I work for the Tennessee Coalition. We have a legal clinic that serves immigrant victims of domestic violence, and we know that a majority of our clients are not English speakers. Their primary language is not English, at least. And if we did not provide services in another language, we would be violating Title VI. One of the things we personally do is we have staff who are bilingual. Majority are Spanish-speaking bilingual because that is a majority of our clients. But when we have clientele speaking other languages, we do, in fact, use language lines. Again, this is only requiring reasonable steps. If you know that you might only have one client per year that's going to speak a very rare language or rare dialect, Title VI doesn't expect you to have somebody on hand to be able to translate, at that exact moment. A reasonable step would be trying to contact Language Line or another service. But if no one is available, you're not going to have a Title VI violation for simply not predicting the future. So what are some proactive steps to ensure compliance with Title VI? Best practices: distribute Title VI information. Make sure all of your employees and the general public have information on what your specific Title VI procedures and policies are, including a complaint procedure. Some suggested methods for distribution include brochures, websites, posters, and other posts on social media or any other form of media. It's important to have a complaint process. It needs to be defined and laid out so that if there is a complaint, the agency can respond accordingly. The complaint should contain a definite timeline for when you should file the complaint, when the individual or the entity receiving the complaint, there needs to be a timeline of when they're going to review and respond to the individual's complaint. These complaints should be kept on file and they should be kept confidential. and it's probably best to have a Title VI coordinator in office, and the person should be in a management position. And part of their responsibility could include making sure everyone in your entity is being trained. So an example of what the complaint process could look like would be requiring all complaints to be written and signed and filed within 180 calendar days of a discriminatory act. You can make sure that the complaint includes a name, address, phone number, and other identifying information if it's needed. The complaint should also include the name of the person, department, or agency who discriminated against you. It's recommended to have them include how, why, or when they believe they were discriminated against. And again, we wanted to include a follow-up on there so that they have some sense of closure. You could include that the complaint will be addressed in 60 calendar days of being received. It's important to know that the aggrieved party does not have to be the one filing the complaint. Someone else can file a complaint and can fill out this information on the aggrieved party's behalf. Another best practice would be to conduct a Title VI self-evaluation. This would be done by the Title VI coordinator. And what they would be doing is ensuring all of their employees have been trained and trained yearly. An employee has been appointed to serve as your Title VI coordinator for the agency. Again, we said that should probably be somebody in management. Part of the self-evaluation would be making sure that minorities are represented on the advisory board. Again, this is part of the reasons Title VI is in place. We want to make sure that the population is accurately reflected. You want to make sure that there is a written procedure for filing a complaint, reviewing a complaint, and when any hearings might be had. Part of the self-evaluation is to make sure that records are maintained regularly and they keep all alleged cases of discrimination confidential. And all staff should be specifically informed about their individual rights under Title VI. It's also important to make sure you keep all records of alleged discrimination, even if it's determined that there was no discrimination. Keep those records of your investigation, the review process, and any decisions that were made. Staff are periodically apprised of their Title VI rights, and contracts from the agency are provided without regard to race, color, sexual orientation, or national origin. Contracts between this agency and other parties could include a Title VI statement of compliance. Title VI posters should be promptly displayed in areas that are open to the public and your employees to emphasize that this is a Title VI program, and make sure you have, again, the complaint opportunities and procedures laid out. Again, make sure that staff are trained regularly and on a yearly basis, and make sure all employees, not just new employees. Another way to ensure that you're being compliant with Title VI is to have that Title VI statement placed in contracts if that's applicable. An example of a Title VI statement would be this. It's one that we have for the Tennessee Coalition, and it states that it shall be against the policy of the Tennessee Coalition to end domestic and sexual violence to discriminate against an individual based on that person's race, color, or national origin. This policy applies to applicants for employment, current employees, as well as persons receiving services from the coalition. you are not compliant, what's going to happen? Well, a few things can happen. One is there could be a withholding of payments under any contracts until it's determined that the recipient becomes compliant. Another thing that could happen if you are not compliant is there could be a cancellation, termination, or suspension of the contract in whole or in part. However, before they terminate your contract, the Title VI office provides technical assistance to help get that covered agency back into compliance. If you would like to get more information on what Title VI is, we have a link here for the Justice website. It's the Title VI Legal Manual, and it's put out by the Civil Rights Division. So you can always go there to look up more information. Now, are there any questions? So I'm not seeing any questions. If you do have any questions after this presentation, you can contact me or others at the Tennessee Coalition. My email is below here. It's bwoosley@tncoalition.org. Again, feel free to reach out to us if you have any questions after this presentation. All right, well, that is it. Everyone have a great day.